Good morning, friends. My today's topic is important judgment of the Madhya Pradesh High Court Indore bench. The question before the Indore bench of Madhya Pradesh High Court was whether the if the relief of possession is not required to be sought by the plaintiff in a suit for cancellation of sale deed when the plaintiff is co-sharer in the suit property, can the complaint be dismissed for that fault? The answer is as below. The bench comprising Justice Shivod Avyankar observed that in such cases, the suit would not be hit by the proviso to Section 34 of the Specific Relief Act, placing reliance on the decision of Supreme Court in Muhammad Ali versus Jagadish Kalita. The court observed that in view of the above said dictum of the Honorable Supreme Court, it is apparent that in a suit for partition, when the property belongs to one co-sharer, it shall be deemed to be held by that co-sharer on behalf of other co-sharers. And in such circumstances, in the considered opinion of this court, it is not required by the plaintiff co-sharer to specifically claim possession as well, and that the suit shall not be barred under proviso to under Section 34 of the Specific Relief Act of 1963. Even otherwise, it found that in the plaint, the plaintiff has clearly averred that the property is a joint family property which has been sold without there being any partition. Thus, on the face of it, the plaintiff's suit cannot be rejected merely on the basis of plain evidence. Hence, also at this stage, the suit cannot be rejected under Order 7, Rule 11 of the CPC. Now, coming to facts of the case. Facts of the case were that the respondent has instituted a suit against the petitioner for cancel of sale deed and permanent injunction for the concerned suit property. Therefore, the petitioners moved an application before the trial court under Order 7, Rule 11 of the CPC. The same was rejected. Agreed, the petitioners moved this court. The petitioner argued before this court that despite the suit property being in the possession of one of the defendants, the respondent and plaintiff did not seek relief of possession in her suit case. It was ever that by virtue of the same, the suit was hit by proviso to Section 34 of the Specific Relief Act, and the plaint was liable to be rejected under Order 7, Rule 11 of the CPC. On the other side, the respondent plaintiff submitted that she was a co-sharer in the suit property and that she had an equal share in it, which was on par with the other defendants. Examining the submission of the parties and documents on record, the court did not find merit in the arguments put forth by the petitioners. It noted that a co-sharer having possession of the property with multiple co-sharers is deemed to having its possession on behalf of other co-sharers. The court further observed that respondent plaintiff had clearly averred in her plaint that the suit property is a joint family property which had been sold without there being any partition. The court noted that on the face of it, the suit could not be rejected merely on the basis of plaint evidence or that it was hit by proviso to Section 34 of the Specific Relief Act. With the above said observation, the decision of the trial court in rejecting the application of the petitioners was upheld and accordingly the petition was dismissed. This is the case before the Madhya Pradesh High Court. The case title is Manorma and another versus Sudha and other CRR 288 of 2023. This is all about today's presentation. I hope you have enjoyed well. Don't forget to share with others and subscribe to my channel. God bless you all.